Bear with me because I'm just going to sort of go down to a basic level and inform our honored guests, Central High School, what we're studying today in the context of this class. We're talking about conflicts of interest. And you know from watching lawyers on TV, they advocate, they counsel, they take into account their client's interests, they try to move the client's interests forward. But there are a lot of sets of interrelated and complex duties and obligations that lawyers have. And that's what we explore in this class called professional responsibility or regulation of lawyers. Lawyers are licensed to practice, and therefore our conduct is regulated. We are self-governing, of course. We have the Kentucky Bar Association and the Kentucky Supreme Court, and they regulate our behavior. And what we are studying are the rules that regulate our behavior, the model rules of professional responsibility. And the Supreme Court has adopted these rules in pretty much the same form that we're studying them, and they govern our conduct. So what we are really concerned with is being good lawyers, not getting in trouble, and not being in the Courier Journal for doing something bad, stealing the client's money, not picking up the phone and talking to the client, not being able to execute the duties competently. So what we have on the board: competence, candor, communication, diligence, fiduciary duty, trust, undivided loyalty. Those are the essential building blocks of the attorney-client relationship. If the client is indeed going to trust the lawyer, we have to exhibit the skills necessary to advance our client's interests. And so we're going to take a simple hypo today, a problem, and analyze how we would do it within the context of Rule 1.7, which talks about conflicts of interest. And we were looking at conflicts of interest in our last class, and we started Rule 1.7. But before I go into that explanation, can one of the Central students tell me what a conflict of interest is? What do you think a conflict of interest is? Yeah.
An issue between the lawyer and their client to where they can't meet their needs that they want because of legal issues.
Okay, what do you mean they can't meet the needs that they want because of legal issues? This is what you said.
Well, we did an example this morning in class to kind of get ready for the class.
Yes.
It's like we did a demonstration where he showed the lawyer the weapon that he used or whatever. He said, since it's between us, you shouldn't be able to tell anybody, right? Like, you keep this in between us, and it's in my best interest that you don't tell anybody so you can help me out. And there was an issue with that because the lawyer just can't forget that he saw the weapon that he used to beat somebody that he's trying to help out. So, yeah, pretty sure that's called confidentiality.
Yeah. So those are one of the interests that those are some of the interests that we identified. We have our own obligations as lawyers, but we also have to represent the client. We have to keep confidences. We can't turn against our own client. But as our students know, we can't assist a client in committing criminal conduct or assist the client in committing fraud. So we started with Rule 1.7 that says a lawyer shall not, that's mandatory, represent a client if the representation involves a concurrent conflict of interest. And then we looked at comment 6, and that told us what these type of conflicts are. There are two types of conflicts under 1.7. One is the representation is directly adverse. What do you think directly adverse means? One of my students can tell us what directly adverse is. This is our little review. What is directly adverse? Yes.
It goes directly against the client's interests.
Goes directly against the client's interests. So now I'm going to try and trick a Central High student. I'm going to say this. So, directly adverse. So I represent a client in a automobile action, personal injury suit, and I am for that client. I am representing the plaintiff against the bad driver. So I represent the client in that. But then there is this real estate dispute as well. I get the case, and I don't know it, but I'm actually suing my client who is a landlord in this property case. So I'm doing two things at once, concurrent representation. I'm representing this client against a bad driver in a car case, but I'm also suing my client in an unrelated action in a real estate case. Can I do that, Central students? It's unrelated. Can I say to myself as a lawyer, not a really big deal because I am for my client in one instance and against the client in the other interest, but it's okay because one is a car accident, personal injury, and the other one is a property action. No big deal. Can I do that? No? Tell me why not. Miss, you're shaking your head. Why not? Yeah.
Well, I think that it would be a conflict of interest because you're almost like competing with yourself.
Competing with yourself? Yeah, Barbara Trick. So that's unrelated though. Can I go back to my client and say, look, we're going to really win this personal injury bad car driving. We're going to make a lot of money too. But there's this little side thing I have to do. It's just, perfunctory. It's not going to hurt anything. But I have to sue you in this unrelated property matter. You're the landlord and your building isn't really up to par. I have to sue you, but that's unrelated to all the money we're going to make in this personal injury case. Is that okay? Why not?
Well, I think that it's just because your goal as to help the client win one case, and then it's going to cloud your judgment in a way.
Clouds your judgment. That's interesting. So that you sort of just introduced this next point, materially limited, but we're going to get to that. But good, very good. So look at comment 6. My students would say, I always talk about the comments and I get tired of it, but the comment tells us this, loyalty. That's what I have up there, undivided loyalty. Loyalty to a current client prohibits undertaking representation directly adverse to that client without the client's informed consent. Now, my little hypo, I could have said, look, this isn't really bad. I wanted you to know about it. If the client says, okay, we get that in writing, and then we have informed consent. I tell the client about all the pros and cons of this litigation that I'm doing against them, as well as any limitations that might be in the car action. And if the client signs off on that and says, okay, recognizing all the things that can happen, we have informed consent, and that conflict is what we call consentable. It goes away when the client knows all the pros and cons and gives us informed consent in writing. But if that doesn't happen, notice this, thus absent of consent, a lawyer may not act as an advocate in one matter against a person the lawyer represents in some other matter, even when the matters are wholly unrelated. So that was the point you were making, that they're unrelated, but you're still going against your own client. You're violating this essential trust of fiduciary duty. You are undermining undivided loyalty. So that's directly adverse. Another way a conflict can come up is if your actions are materially limited. And you sort of introduced this too when you said you're going against your own client in another action. The things that you may be able to consider will be limited. Maybe you won't go as hard in one action against another interest as you would normally if your attention wasn't taken up by this other matter where you're actually going against your client. So materially limited, if you look at comment 8, tells us that a conflict really exists if you cannot consider all of the options that you normally would because of some other interest that you represent. So you go through this checklist. So even if the conflict is not directly adverse, you have to ask that or question. Is it materially limited? A conflict of interest exists if there's a significant risk that the lawyer's ability to consider, recommend, or carry out an appropriate action for the client will be materially limited as a result of the lawyer's other responsibilities or interests. So there's something outside of this attorney-client relationship that may impact the way the lawyer represents the current action. Can I consider all of the options? And we're going to see that in our little problems that we'll be doing in a minute. So after we determine if a conflict exists, it might be directly adverse or it might be materially limited. Okay, a conflict exists. Does that preclude us from taking the representation? So if a conflict exists, can we just say, okay, that's it? We go home? If a conflict exists under the rules, what can you do? Yeah. Yes, really. I'm sorry?
You can try to get consent.
Good. You can try to get consent from the client. So you go through this checklist. We know who the client is. Does a conflict exist? Yes. But even though there is the existence of a conflict, you may be able to get consent. And that's under Rule 1.7b. It says, notwithstanding the existence of a concurrent conflict of interest, a lawyer may. So students, may means permissive. You might do it, you might not do it, but you have the discretion to do it. It's permissive. You may represent the client if you get informed consent. But what does a lawyer have to do before he even gets informed consent? A lawyer has to first determine that he or she reasonably believes that he or she can provide competent and diligent representation. So the first thing you do, yeah, this conflict exists. Let me look at the scope of both representation. Try to look down the road about things that might happen or develop. And if I reasonably believe that I can competently and diligently represent the client, that's step one. Then step two, I have to determine, is the representation prohibited by law? If it's prohibited by law, I can't take on the representation. So for example, some government attorneys may not be able to take on a certain type of action. They may be precluded because of their job. Or your firm may say, we practice in this area and the rules of practice in this area say we cannot take on this type of action. So after you determine if you can competently and diligently represent, yes, you have to ask, is it prohibited by law? If it's not prohibited by law, you go to the next thing. Is it the same litigation or transaction? So you can't be on both sides of the litigation. You can't be a prosecutor and a defense attorney in the same action. You can't be on both sides of a public offering. Because there's no way to diligently and competently represent the client because your goals will always be conflicted. So you can't be on the same side of the V. And so after you determine that I can competently and diligently represent, it's not prohibited by law, I'm not on the same side of the V, the last thing it says, and you need informed consent. And informed consent is more than just saying, listen, client, I'm going to do this, that's okay. You sign off on it, okay. You take the client through all of the pros and cons of this type of representation. And the client, knowing that, will say, okay, I recognize that I give informed consent. That is what we call a consentable conflict. And we noted in our last class that most conflicts are consentable, but there are some conflicts that are so bad, even informed consent isn't going to obviate the severity of that conflict. Like if you're a criminal defense attorney, you represent two criminal defendants, and you get one to give, quote, informed consent to let us turn against you. I give informed consent that you can use all the evidence that you have that we both shared in this common defense, and you can use it against me. And the criminal defendant signs that. That would undermine the Fifth Amendment, that would undermine the Sixth Amendment, that would undermine undivided loyalty, and there's no way that informed consent would allow us to carry forward that representation. So although most conflicts are consentable, some are not. And so that brings us up to where we are now. That's on page 255, what I just did, and also the chart on page 256. I'm sorry, 251. The chart is on page 256. Okay, so now we have sort of what brought us here today, and that is this little hypo that we're going to start. It's on page 269. The injured passengers. The injured passengers. So I'm going to give out the facts basically. I want the central students to follow along, and then we're going to analyze this claim. And it's just going to keep getting worse and worse as we go through. So keep in mind all of these things: competence, diligence, candor, communication, fiduciary duty, undivided loyalty, keeping confidences. All of those things are what's going on in the lawyer's head on all matters. So we have this scenario starting on page 269. Jill and Rima, they're passengers in a taxi cab taking them from Sanderford Field Airport to their home locations. They met on the airplane. They say, let's share a cab. They get in this cab. The cab driver is really a horrible driver. It's driving fast, weaving in and out, and ultimately there's a crash. Crashes into another car. Both Jill and Rima are injured. We are personal injury lawyers. We like the heavy hit. So we represent personal injury act. They want both of us, they want us to represent both of them. They don't have a lot of money, and they say, well, this joint representation will work. You'll be our attorney, and we say, okay. Now, there's some things that we're going to have to look at with Jill and Rima. So we have this common joint representation. That's good. And we're saving money. And we represent Jill. And we represent Rima. So we're united in a common cause against the taxi cab company, or get some money from that taxi cab company. And so there are a number of things we're going to have to talk about in terms of the taxi cab company, and we'll see as the problem develops, it gets a little bit more complicated. You know, we have insurance liability issues. We have litigation strategy issues. We have whether or not we're going to settle, all of those things. But it basically starts with our conversation with our client. And from our conversation with our client, we have a number of things. Jill suffers, not diminishing the significance of her injury, but Jill suffers whiplash. You know, and she'll need some rehabilitation, but not totally devastated. She'll need some physical therapy. So not totally severe, but she's in a car accident. Rima has severe fractures. Abdominal injuries. spends 5 weeks in the hospital. And you know, to save money, we say a contingency fee. If we win, we get a certain percentage of the winnings. We take a third contingency fee. One third, and we get a third. And our attorney expenses. So a contingency fee is an exception, just as an aside to my students. Contingency fee is an exception. We know that there's a general prohibition from the attorney gaining a stake in personal interest in a transaction or litigation. But contingency fees are an exception to that general rule because we want people to have access to representation. So we say we're going to do a contingency fee. And the first question is, can we actually represent both of them? Can we represent Jill and Rena? And what information would we need to find out in order to answer that question? So the first question is, can we take on this joint representation of Jill and Rena? Can we? Yes. Ms. Paul.
Yes. Can.
Go ahead.
Oh, I mean, it's coming from the same, accident, I guess, so their interests there wouldn't be a conflict really, besides their different injuries, you just have to, there'd be.
Uh-huh. You said different injuries though. So is there anything you want to kind of be careful about? I mean, it's good now. We're just talking about money. We want to get this taxi cab company. You know, insurance is going to be an interesting thing. We don't have all the facts, but in real life, we want to know what that insurance policy says. So, go ahead. What do you think? Insurance, but different injuries. Rena's injuries are a lot more severe than Jill's. That's a problem. Ms. Moore, go ahead.
Need more information about the wreck. I would want to know the details about what happened. Make sure there's not any kind of reason for them to go against each other at some point.
Yeah, see, that's going to come over the horizon too. That's going to be in the next part of the problem. Everything, so what I'm emphasizing is this. Whenever you do a joint representation, these are the type of candid conversations that you have to have. When they're first coming together, everything's rosy. We're going to beat this taxi cab system. We're going to keep moving in the right direction, and everything's going to be fine. But there's a whole series of things we need to find out. Ms. Boyd, you had your hand.
I was gonna say it would just be important to counsel the client so that they know that they would receive different amounts of money based on their interests.
So this is these components are going to come up. We want to talk about insurance. We want to anticipate anticipate possible divergence. In other words, we're commonly united now, but things can come over the horizon. Different recoveries. Anything else? Yes, go ahead.
To go along with what you said, I think that since you can represent them together.
A little bit louder.
Oh, you can represent them together, but there would become a problem with accumulated insurance bills for Rima because she spent 5 weeks in the hospital, and she has way more severe fractures and bruises, and it's just all around more serious for her. Where it would be along the same for Rima versus Jill, because she only has whiplash, she'll only bleed.
That's good. That's good. So these are all of the discussions we're going to have. We're going to talk about the contingency fee. We're going to talk about the insurance. We're gonna anticipate possible divergence. There may come a point where we may have to part company, and one of you or both of you may have to get independent counsel. We may have different recoveries because of the severity of the injuries and different expenses for each client. So that's gonna affect recovery, different expenses for each client. Now take it back. Notice what we're doing. We're looking at competence. So all of us are saying, yeah, that's okay. We can represent diligence. Yeah, we're going to work hard and do everything we can. Candor. We're having this discussion with our client. What about communication? We haven't talked about communication. What about communication? How are we going to conduct communication between these joint clients? Is there something we want to say within the rule? Like, for example, go ahead.
I was just gonna say maybe let them know like each step of what's going on and how each person's wages can be divided.
Okay, so that's the general nuts and bolts thing, but what about how we will communicate under 1.4? Because remember what 1.4 says. And so some of these rules, they just give us a general guideline because they rely upon us to sort of use our expertise. So as you pointed out, we're going to promptly inform the client of any decision or circumstance to which the client's informed consent is required. Reasonably consult with the client about the means by which the client's objectives are to be accomplished. Keep the client reasonably informed about the status, as you say. Promptly respond to requests for information. We'll do that. And notice this. Number 5 under 1.4. This is why we have to sort of structure our conversation this way. Consult with the client about any relevant limitation on the lawyer's conduct. When the lawyer knows that the client expects assistance not permitted by the rules of professional conduct or other law. So that's something illegal, that's fraud, and there's also any limitations that might arise that come out of this joint representation. So we really have to have this conversation. What about how information will be shared? We didn't talk about that. That's one of the important things you have to ask when you have a joint representation. What about how information will be shared? So for example, can Rima come to me, we're the attorney, can Rima come to us and say, look, I like Jill and everything, I'm not turning against her or anything, but this is something important that you should know about this accident. And then she tells you something that doesn't point a finger at Jill or anything, but just a secret confidence that you should keep from me as my client. I don't want you to share it with Jill at all. Can you do that? Yeah.
Well, I feel like if you want a joint representation.
A little bit louder.
If you want a joint representation, then you should have been ready for sharing your information with the two people since it's joint. But if you wanted to keep it confidential, just you two should just did it on your own and let Jill do it on her own. So I feel like that they both should have the right to both of their information since they're both going in it together.
Okay. So I think you can have this representation, but you have to tell them that confidences must be shared. That's the only way this thing is going to work. Confidences must be shared. And also you want to talk about material limitation. Because notice, even though you have two clients who have been injured, one's injuries are significantly more than the other. So that might mean that you might not be able to be as aggressive in Jill's claim and pursuing her claim because of Rima's larger claim. And there is certainly the possibility that the insurance company will come to you knowing that this is a joint representation and try and drive a wedge between you and your two clients. So those are all things we should consider. And then the book asks us, might there be a non-consentable conflict in this case? Do you think this is a non-consentable conflict? In other words, a conflict so bad that consent doesn't even allow us to move forward with the representation. Do you think this is a non-consentable conflict? What do you think? I don't think at this point we have a big problem. After we have this type of discussion, at this point, assuming that there's adequate insurance, and there's no indication in this fact pattern yet that there isn't adequate insurance, this is a conflict that could be consentable. Do we need to get informed consent before undertaking this joint representation? So this is why we discussed the components of the attorney-client relationship. Do we need informed consent in this case? Yeah. I don't think it's mandatory, but you would be smart to do it because you can get it in writing, and you also have to talk about the representation, at least at this point of the representation. Something that is coming over the horizon might be that you are materially limited. You have one client with a big dollar recovery, and Jill's is smaller. But you still have to represent both of these clients competently and diligently. They have a common interest against the taxi cab company, but the amount of money on the line may cause that commonality to disintegrate when we start talking about money. So, do we need to inform consent? Informed consent, I would say yes, because you need to talk about the material limitation, and it would be good to get that in writing. And so, if we do need to get informed consent, so that the client is fully informed, I'll put client is fully informed about consequences of the joint representation. And so that's all of this over here. We talk about the contingency fee. We talk about the insurance. We talk about what happens in the event of a possible conflict. We talk about the possibility of different recoveries. We talk about different expenses and how that might be calculated. We talk about sharing confidences as essential to the representation. I also mentioned probably attorney-client privilege and how that is protected as well. So we want to emphasize, in order to get this informed consent, undivided loyalty, confidentiality, attorney-client privilege, and all of the ramifications of that representation. So that's fine. So, should interest diverge, we might need a independent lawyer. So that's good. So that's the kind of conversation that you want to have. So the answer to this first problem, 6.1 on page 269, is that we go through all of these steps, we get informed consent, and we should be fine. We just have to anticipate conflicts on the horizon. One thing I want to mention is look on page 270. This is just setting up some things we'll talk about in later chapters. But another concept in conflicts is this notion of imputation. Imputation. So conflicts can travel throughout the law firm. So you'll see under this rule that the law firm is one lawyer. It might be 500 lawyers in the law firm, but if one lawyer has that conflict, it can flow through the law firm. And there'll be some things that we're talking about, like screening and how we get informed consent and those types of things that could alleviate that conflict. But if you look on page 270, this concept of imputation in Rule 1.10. So a lawyer that is associated with a firm, none of them shall knowingly represent a client when any one of them practicing alone will be prohibited from doing so. Under Rule 1.7, which is what we're talking about, current conflicts, or 1.9, former clients. So I could be a lawyer in a law firm that has a conflict with one of our current clients. That conflict is imputed to the firm, and we're going to have to do something about it. We're going to have to talk to the affected clients, maybe get informed consent. If a client does not give informed consent, what happens? If you determine a conflict exists, you're trying to go through all of these steps, you ask the client, can we have informed consent? And the client says, no, I know you think it's not a big deal, but I don't feel comfortable with it. I don't want you going against me. Can you take that matter? No, can't do it. So that's why informed consent is so important. But back to this imputation thing. We look at it as one lawyer. So if one lawyer has a conflict because of a current client or a former client, the law firm cannot take it on in the absence of informed consent. You see, letter C to Rule 1.10 says, that disqualification prescribed by this rule may be waived by the affected client under the conditions stated in 1.7. So that's informed consent. Now, if I just have a personal interest that creates a conflict, the law firm can take on that case because that type of personal conflict isn't imputed to the firm. So I work for a big multinational law firm, and they always represent the U.S. government and the Defense Department. I hate the Defense Department because I had a bad experience in the military, so I just hate everything that has to do with the U.S. Department of Defense. Now, I probably couldn't represent them because of my limitations. I wouldn't be as effective. I don't like my client, all of that. But that is not imputed to the firm. That's just something personal. They'll keep me away from it anyway, and the other 499 lawyers in the firm can take on the matter, and it's no conflict. So that's what that language, personal interest of the disqualified lawyer does not present a significant risk of materially limiting the representation. Now, look on the top of page 272. That's what we did to illustrate the point that directly adverse means going against your client. We don't care if the matters are related or not. So that comment that says even if the matters are wholly unrelated, it's still directly adverse and is a prohibited conflict unless you get informed consent, is what we're talking about in that particular scenario. Now look at problem 6.2 on page 273. I thought you were my lawyer. So I'm going to erase this on the board, but this is what we've been doing. We've been identifying who the client is. We've been asking, is there a conflict? What type of conflict is it? We've been saying, even though a conflict exists, can we still represent that client? When we ask that question, we have to say, can we competently and diligently represent? Is it prohibited by law? Are we on the same side of the V? The answer to all of those is okay, then we need informed consent. If we get informed consent, all 4 of those steps are met, we can continue. That is the consentable conflict. And so in this new problem, it sort of illustrates everything that we've been talking about since the beginning of this class. And the title of the problem is, I Thought You Were My Lawyer. So this is to illustrate this notion of, well, it's unrelated, so it's not really a conflict. We're going to see how these things sort of play out so that there is a conflict. So this also illustrates how careful you have to be when you're taking on clients. So if you look on page 273, you're looking at problem 6.2. I thought you were my lawyer. So in this problem, we're asking this basic question again. Is this conflict consentable? In other words, after we explain the conflict to the affected parties, will we be able to get their informed consent to keep moving forward with the representation? Is this conflict consentable? So here's an instance where the firm did not detect the conflict. You have an accident case up here, and we have the law firm Shelton and Condenas against the bus company. Our client is Dory Hathaway. Plaintiff. So that's good. We are also involved in a divorce action. So I'll put unrelated in quotation. Same firm. Against So we represent Dory Hathaway against the bus company. We're the plaintiff in one action, and we're are against her in a divorce action where she is the defendant. We represent. There's a glitch in our system for detecting conflicts, and because her husband has a different last name, we didn't detect it. But this is Dory Hathaway's husband. There's some other, I'll just put another law firm. So that's the really bad thing. Directly adverse, I guess. And then we have a series of questions. You know, they have no children. This is on page 274. But they do have some property. There may be a dispute about property division, money again. The lawyer handling the divorce for Bolesky has just discovered that Dory Hathaway is a client of the firm. So we have already signed contracts agreeing to represent Dory in the accident case and Kevin in the divorce case. And we are ethics counsel to this firm. What, if anything, should we advise the firm to do? And it says, evaluate this case under Rule 1.7. So what do we do? What do we tell the firm? We have a meeting in 20 minutes. We have to figure out what we're going to say. We have to advise the whole firm on this problem. I thought you were my lawyer. So what is it? Yes, we are your lawyer, but we're suing you too? Yeah, this way.
So, Rule 1.7A is a mandate that shall not represent a client if it involves a concurrent conflict of interest. So we have a conflict of interest that's happening with these two clients at the exact same time. They are directly adverse to each other. Any settlement claim or whatever that Ms. Hathaway would get would be a matter that would be involved in her divorce case. And diligently representing Kevin Bolesky in order to get, the most out of his divorce settlement would be adverse to, her interest in keeping it. We would have the conflict in being loyal or diligent in representing both of their interests to get out of both cases as much as they want.
So good. So notice what you did. You took it through. So you did competent and diligence, and you were almost stuck there because how can we diligently represent one client's interest by sacrificing the interest of another? That's one thing. And we might be materially limited in what we do. I mean, here we're trying to get money, and you say this money might become impacted in the divorce case because it's an asset. In a lot of different combinations, we would have to make a decision about one client's interest over another. So there certainly is a diligence problem. There's a materially limited problem. The materially limited problem is how hard do you push for either client. Do we push harder for Dory because we know the bus company has a lot of money, and then how do we hide that from Kevin if he's our client and we're actually going against Dory? So there are problems with both directly adverse and materially limited, as well as the standard of diligence that we might not be able to meet. So I guess the kicker is this, though. We've assumed that there's a conflict, and we've also pretty much concluded that we can't go forward with this representation? Can we keep one client and drop another? See, on 274, you have this. Assume you decide that the firm cannot represent both Kevin and Dory. I think that's right. Can the firm represent one of them? If so, can the firm choose which client to drop? So what do we do about that? Ms. Wagner, go ahead.
Sure, so, you're gonna have to make sure that your representation of either client doesn't, I mean, if you were to keep one, doesn't hurt the other one. That's gonna be hard as far as the cost to the client, the time, delay, whatever, in getting their cases. Having to, replace their representation.
Mm-hmm.
You might be able to drop one client if they both consent to it. Drop one to keep the other if it's
Yeah.
consented.
You think we'll get consent here?
No,
No.
no.
Probably not. I mean, you could ask, but probably not because of this divorce. I mean, we don't know if it doesn't say it's a bitter divorce or anything, but I can't imagine someone saying, okay, yeah, you can continue suing me in this divorce action while you're representing me in the bus action. Because a client would normally be a little bit skeptical about the level of representation if you're doing two things at the same time. Ms. Moore, go ahead.
You have more of an obligation in order to her already, her cases already been
Yeah.
decided.
Yeah, I probably keep Dory. But are there any problems with that? So I think you're right. The firm should at least withdraw from representing Kevin in a divorce case to avoid the possible adverse use of information, confidential information against Dory. Notice if we kept both of these cases, we would have confidences from Kevin that we could use against our own client Dory in this divorce action. So we need to get away from Kevin. And I think consent is unlikely. And I guess if we did keep Dory following Ms. Moore's reasoning, there are probably no confidences from Kevin that would be relevant in the personal injury case. And we probably can continue representing Dory if she consents to moving forward. So we'd have to tell Dory all of this. And we said, look, we're gonna drop Kevin, we still wanna move forward, is that okay? Would you inform consent? That type of thing. But you'd have to carefully, there isn't enough here, but you'd have to carefully analyze this information. If there was some information that we had that could also be used against Kevin, I don't know what that would be, then we might have to consider withdrawing from both. There are scenarios where you have to withdraw from both. Here I think we're okay because there isn't any information, at least in the facts, that confidences that Kevin would have shared would be relevant in this personal injury case. Continue representing if Dory consents after being informed of this conflict. Now, look on page 277, something has changed here. Now we're up to scene 2. The injured passenger, scene 2. So this builds upon our previous problem. Here, oh, I'm sorry, I should tell you what happened this is a real life case. Let's go back to 6-2. This is a real life case. I thought you were my lawyer. So in real life, the law firm was fired from the personal injury case after the client discovered that the firm was representing the wife in a divorce case. That was just the facts of the real case. What do you think the firm did when it was fired from the personal injury case? Is just walk away and say, oh, okay, what do you think the firm did? No. Talking in relation to the former client. There's a former client scenario too. You may not be able to go forward when she becomes a former client because we would be against her interests. But what do you think the firm did in terms of being terminated from this representation? Think money. Yeah, I hear it. What's somebody say? Sue, we want our money. I mean, we want to recover the fees for all the work that we had done on the personal injury suit before we were fired. And this was an early case from the 70s, and we just really put in the model rules, and the court went on to say, well, everyone is still learning about these rules, and it was a conflict. However, the court concluded that the firm was entitled to the fee for the work that it put in up to that point that it was terminated. So I think the answer to our question is this conflict consentable? Probably not. I mean, this would be a general case where if we thought that the parties would say, okay, that's fine, we certainly could. It's not sort of the type of thing that could not be cured by consent. This is just an instance where informed consent probably would not be given. You have two spouses divorcing, and the possibility of the firm representing the client in one case and being against the client in another.
Mr. Paul, I have a question.
Yes, go ahead.
Did they sue Ms. Hathaway or whatever her name was in real life, or did they just try to collect that from her settlement? Did they just sue her, or did they try to collect it from her settlement later? Like, did she settle the case later and they tried to collect it from that settlement, or did they just sue her outright?
I think they just sued her outright.
Okay.
Yeah, it's from the 70s, but yeah, I think they just sued her outright. Yeah, go ahead.
Would this be a case where either one of the clients, if they were injured and could prove that they would have recovered more, could sue the law firm or
Malpractice because of the
malpractice?
conflict? Yeah, if they could connect it to that, yeah. If they could say, and you know, they could bring that action, but I don't know how successful they would be. That's hard because that case within the case, you'd have to prove, yes, we would have been successful and we would have received this award. But that's certainly something that could be done. And some malpractice actions are based upon a conflict. You could not competently and diligently represent me because this conflict existed. Therefore, I didn't get the result that I was anticipating. Know that no results are guaranteed, but your performance fell below the level of a competent attorney because of this conflict. So yeah, you can make that argument. Always the stumbling block, though, is going to be the case within the case. Yeah.
All right, so last question on this one.
That's all right.
If you have the conflict check you're supposed to do before you agree to representation, is that something that you run before your first meeting with a client to make sure that you're not going to even anticipate shared confidences? Like when the one attorney was giving advice at the first meeting that we talked about with the other defendant.
So the two clients are there, you mean a joint representation?
Before they take on Kevin, they should have run a conflict check on both of their names.
Yes, they should have. But I really don't, this always troubles me about this fact pattern. It just casually says they didn't catch it because the last name was different. But I think your suggestion, it should be a lot deeper than that, and run the matters that way. And so, yes, I think what you're talking about is sort of like a preventive approach to even entering into this conflict if you check it before. I mean, and it all varies. This is probably a smaller or middle sized firm, so maybe the conflict apparatus isn't as complex. Larger firms, they have a ticker and they always are checking weekly whether or not a new matter being brought in is a conflict. So there are ways to anticipate conflicts, but sometimes things do slip through the cracks. So, but a long-winded way to answer your question, I think yes, you can anticipate conflict before that first meeting where you're sharing things that could be used against a potential client. Yeah. Okay. All right. So problem 6.3 is where we are on page 277. This is a joint representation again. So we're all together up to this point. So joint representation. We have informed consent. And we have decided that we are moving forward. So everything's good. Now some of the things that we have anticipated in this joint representation start to come to life. And we see on page 277, we have concluded that we can represent them both. That's what we did in the last problem. We've obtained their informed consent because we talked about all the things on the board. And we've filed suit on behalf of each of our clients. We've done some discovery. So things are moving. Done a little bit of motion practice. The attorney for the taxi cab company contacts us to discuss a settlement. And so, settlement. I want to discuss the possibility of settlement. So the attorney for the cab company sort of drops an implicit hint that he may offer $350,000, a lot of money. And you're thinking 1/3. $350,000 for Rima based upon the severity of her injuries, and $50,000 for Jill. So what do we have to do? How do we approach this? Remember communication. What should we do? How should we respond? So this is a situation where our positions change. Positions change. And we have this joint representation, and we're really concerned about how we continue to represent these clients. So we have to go through what we've gone through before: competent representation, not prohibited by law, we're not on the same side of the V, and informed consent. There is a possibility that our clients' interests will be adverse to each other. So what do? And we have to communicate. You know, under 1.4, all settlement matters have to be communicated to the client. Yes, I'm sorry, go ahead.
You can't really do anything until you inform both of them about
A little bit louder.
You can't do anything really until you inform both Rena and Jill about these settlement offers.
Okay, all settlement offers must be communicated to the client. So you know we can't even settle this matter without the client's consent. Basic component of communication. All settlement offers must be presented to the client. So what do? So, you know, a lot of scenarios, this is, will money come between our clients, I guess what I'm asking. Go ahead.
I was going to say, it says it's only like a hint of an offer, so I think that gives
Yeah.
you a little bit of leeway at
Sure.
this stage. And
Yeah.
I think what I would do is sit down with each of them individually.
Yeah.
And with Rima say,
Oh, wait a minute. Why individually though?
because I think if you put them together and say this is the offer, you have the chance one of them likes it and one doesn't. But if you sit down with just Rima and say, if we were able to get $350, would you be okay with that? And then you sit down with Joe, if we were able to get you $50,000, would you be okay with that? Because then that gives you the opportunity, if one of them doesn't like it, to go to the taxi company and say, you know, hey, this client is not going to be okay with this offer. And see what
Yeah,
they
I'm
come
worried
back.
about that a little bit though. So after that you bring them together and then do that, or
I mean,
see,
I think-
but what worries me is this: of course, it's human nature. You pick the client with the biggest thing, with the biggest amount of money attached to it. So look, will you accept this? And you know, Jill isn't even in the conversation. So that's interesting. Well, I mean, you'll bring her in eventually, I guess, but then you know. Then when you're talking to them both together, it might come out that you sort of talk to Rima without Jill. So if this is a joint representation, remember one of the components that we had in there was that communications and confidences would be shared up front. And that approach isn't necessarily horrible, but I'm concerned about sort of fostering some dissension maybe when they wouldn't need to be in. Maybe you just bring them both together. This is $350 for you. You know that your injuries are more severe. $50 for you, Jill. Is this something you could accept? Now, best of all possible worlds, they both say, well, this is a lot of money on either scenario, and I think that the damage award is proportionate to what we suffered, so I'm fine with it. But maybe both clients say, no, that's not even enough for Rima. Rima says, no, I want $650,000. I see your commercials on TV. You get at least $650,000. That's what I want. And I don't even care about Jill. You talk to Jill or whatever, and we're all together now, not in separate meetings, but they start to sort of dissent. What if both clients want the max? That's one thing. So it could even sort of blossom into something that is non-consentable. It could be consentable if both clients say, look, this is nice money, I'm tired of this, we've been doing this for a year, or we both consent and we move on. But when they start fighting about money, their interests could be adverse to each other. And so you look on the page, top of page 278, so this could be a scenario where it's okay, we both consent to this amount, we move on. If they both want the max, our interests are diverging, and there could even come a time when we want independent counsel. This second scenario does squarely puts us in that position. We continue representing both clients. They both reject the settlement offer. So we've had this conversation, we're all in the same room to talk about it. During our deposition of the driver, he states that Jill was very drunk. She got into the cab and the accident occurred while Jill was arguing with the cab driver. So we're both together again, but I have to have this kind of conversation with you. I heard from the deposition, Jill, that you were drunk. We asked Rima and Jill about Jill's behavior in the cab, and they both confirmed that our client Jill was drunk. In fact, Jill tells Rima after the accident that she gets nervous in cars even when she is sober, and her anxiety increases when she was drinking. So there's a real possibility that our client's behavior contributed to this accident. The jurisdiction, of course, has abolished joint and several liability, so we're talking about comparative negligence. So Rima sues the driver, but does not sue Jill, and the jury finds that Jill was 60% responsible for the accident. Jill is only going to get 40%. I'm sorry, Rima is only going to get 40%. What if Rima wants 100%? How does this information affect our representation of Jill and Rima? So we have a situation where now in the second scenario, we have some information that isn't favorable to Jill that we can use on behalf of our other current client, Rima. Rima is going to get lower recovery unless she wants to make up that only 40% that she'll get in comparative negligence. She'll only get 40% where she has the real possibility of getting everything if she sues Jill. What do we do there? And so we have to advise Rima that she may not be able to collect in full unless Jill is sued. Notice having this conversation. And we have an obligation to warn Jill that Rima might sue her. And so we'll leave it there. When we come back, I want you to answer that question. What must we do? One option is to keep Rima and throw Jill under the bus. But can you do that under the rules? Have a good afternoon. You're welcome to stay. This program is going to start at 12 o'clock.